Howdy, everybody. I'm Charles Garrion, and it's great to see all your faces. So extremely exciting. The first thing on this history, and this is all pretty much legal history. And as I look at this history, I see a huge social history, a scientific history happening behind it. We're all familiar with the devastating Smith decision that established the basically overturned many years of jurisprudence that allowed accommodation of free exercise in employment and other situations. That was authored by Justice Scalia, who has now reached his just reward, and that stimulated the signing of RFRA by President Clinton 3 years later, which established the law that we are familiar with as basically reestablishing the First Amendment right to exemption from restrictions of general law that had been the case before the Smith decision. Then in 1966, November of 1966, California, and this was by initiative, established the first medical marijuana regime. 2006, thanks to Jeff Bronfman's sponsorship and some great legal work, and a surprise response by the Supreme Court, at least a surprise to me, the UDV decision came down, and we actually found that RFRA had teeth, and it actually would supersede the Controlled Substances Act for that narrow purpose of allowing the free exercise of religion for one entity, as we know, the UDV. January 2009, the DEA releases its quote-unquote RFRA guidance, which we're going to talk a lot about. And you see Brad there. I want to defer to Brad's knowledge and expertise on the guidance from the administrative law perspective. Right from the outset, his excellent work on that has helped me greatly to understand it. We can see that the DEA was doing some hard thinking right in January of 2009 because 3 months later they lost in the Dimey case, Church of the Holy Light of the Queen versus Mukasey up there in Oregon in front of Judge Panner. And so at that time, apparently they decided they wanted to get ahead of this problem. I would suggest that they probably said, this has not gone well. Arresting Mr. Goldman didn't work. Judge Panner really didn't buy our claims. We need to do something to at least appear like we're opening the door to providing an exemption regime. December 2016, I would call this the darkest hour in our collective history of visionary churches, when the DEA made so bold as to send 2 visionary churches, Soul Quest and Ayahuasca Healings, an invitation to submit a petition to the DEA. Then we had the surprise that President Trump was going to be our leader in the Oval Office, and there has certainly been a reign of misfortune resulting from that, but there is some silver lining to this overarching cloud, and that is, I think, these 3 executive orders that came out. The first, May 4th, 2017, promoting free speech and religious liberty, was followed up by Jeff Sessions's federal law protections on religious liberty a few months later in October. And taken together, I don't know how many of you folks have read through those, but taken together, they really strengthen the claim that visionary churches may have to make at any time when they interact with federal agencies, which is that respecting religion and giving full effect to the law that exists under RFRA is the law of the land, and that federal agencies need to respect it. So I think that that executive order and AG Sessions' memo about it are pretty significant and will be significant when cited to courts and other authorities. Next we come to kind of the apotheosis of all of this, which is Executive Order 13891, rule of law through improved agency guidance documents. And this requires, through an Office of Management Budget implementing memorandum that was adopted shortly thereafter, pursuant to that executive order, all administrative agencies were supposed to review the way in which they were using these guidance documents and publish by February 28th, 2020, all of those guidances that they're going to carry forward with as administrative guidance within the limitations prescribed by the executive order. Or if they didn't put them on that website, then they would allow them to lapse and they would only be useful for historic purposes. So this obviously would be very helpful in, is now very helpful in making clear what Brad argued very effectively in his July article last year in Chacruna, that this has never been an enforceable order, has never imposed any obligations upon visionary religions to go through this procedure. And I'm gonna just selectively unmute Brad here because he might want to say something anytime. Let's see, I'm trying to. There you go. Hi, Brad. Feel free to speak at any time because this is definitely your bailiwick.
I'm happy to jump in if you want. Just let me know.
Okie doke. Thank you. So then we have Executive Order 13892, which is also of importance. I'm not going to go through it right here, but it is one more that puts some strength in the hands of those who are having to deal with administrative agencies and avoid excessive overregulation. May 7, 2019, Denver decriminalized personal use and possession of psilocybin mushrooms. Shout out to the Denver, was it called? DNI, is it?
SPORE. SPORE, S-P-O-R-E, which stands for...
Okay, thank you. June 4, 2019, Oakland decriminalizes personal use and possession of mushrooms and peyote, as I understand it. Haven't read it myself, so caution there. January 8, 2020, after collaborating with a number of the folks who were here on this call, I sent off that letter that I sent you all a copy of. If you were one of the people who helped revise it, thank you so much. Really improved it a lot, I thought. Sent that off on January 8th. So at least the DEA couldn't say that they hadn't become aware of the president's executive order and the Office of Management and Budget implementing memorandum. And I don't know if any of you folks have checked, but I have checked over at DEA.gov. I have done a site-specific search for any reference to RFRA or religion on the DEA website. I have found nothing. I have not found a special page for guidance. I just don't think they paid attention. So that puts us in a situation where I think we are post-guidance. And I think it would be a really interesting thing. We actually reached a consensus among the attorneys here that this is the case, that we are seeing, if we have the courage to see it and declare it, that we can tell our clients that the guidance is an imaginary obstacle that you do not have to get involved with, and that if you want a piece of paper that gives you an exemption from the Controlled Substances Act so you can practice visionary religion, is read that RFRA statute. It says go to U.S. District Court. And the DEA will not be able to tell the judge when you get there, or at least will not be heard to argue that you should have gone through their procedure first. As Brad has said, there's no exhaustion requirement. So I'd love to find out if we have that consensus. I think we do among the legal minds here. But it still doesn't open doors to the two rights that visionary churches most need. They need legally safe access to their sacramental substance. It's kind of redundant to say, but two, they need confidence that they'll be safe from prosecution for possession, manufacturing, or use of controlled substances under federal or state law. And I think the question is, how are we going to go forward? I know there are some of us, we have all kinds of different ideas, but it's a fun new world to go into where I think we can consider these things. And so I've got these questions. I'm just going to walk through them real quick, and they're phrased my way. They're slanted. You can respond to them in any way that you like. And the way I thought we could handle this is I would bring each question up and open the floor for discussion. I would give my own thoughts on it briefly, and then open the floor up for discussion of it. And then we'll try and work our way through them. We may get bogged down and not get to the last of them. I don't know. Talked a bunch. So I'll start out. The first one, could the DEA ever be a proper steward to dispense access to a sacramental substance? My own feeling is that constitutionally, it does not work. The DEA is well aware of the fact. I really enjoyed reading the deposition of the DEA employee who tried to explain in the Church of the Holy Light of the Queen case, tried to explain how they would actually decide an exemption. And it was really funny because, so one answer was, I would boot it upstairs. It was just, well, suppose you have to make the decision. Suppose there's no upstairs. It absolutely did everything possible and never came to grips with the core issue, which is how will you decide if they're sincere or not? It's just, and here's my short thought is that any attempt to determine sincerity overlaps so closely with the forbidden determination of reasonableness that it just can't be done. And you really are going to come to a situation where to truly honor free exercise, you have to trust the churches to be honest, and you have to trust practitioners to be honest. It's just the way it goes. You don't actually, no one's ever, passed a Catholic test, If, for example, the test were, do you strictly adhere to all Catholic doctrines? I don't know one of my relatives who adheres to the contraception ban, not one of them. They all two-person families, all Catholics. So these tests, I just don't think that the DO will ever be able to administer a test. I think the Congress put that in the court's laps, and I think that it's really going to end up staying there. But obviously, the DEA is going to have to administer exemptions. It's got to issue exemptions. It's got to have some sort of way to stay in control of controlled substances. So that's my thought about that. And now I will ask you to go ahead and respond to that as you like, and please introduce yourself as you do. All right, let's see. Let's stop sharing. Boy, I see a lot of faces here. Anybody have any thoughts about that?
Hi, this is Rob Heffernan. Hi, Charles. You just wanted people to respond to that first point there.
Right.
Yeah. Okay. By the way, Oakland, you mentioned mushrooms and I forget what other substance, but they actually opened it to all natural psychedelics, in my understanding.
I'm so glad I made it clear that I was somewhat ignorant about that. Thanks.
Sure.
It's DMT-complaining plants like ayahuasca, psychedelic cacti, including mescaline, or mescaline-containing cacti, so peyote and San Pedro, psilocybin mushrooms, and ibogaine.
Awesome.
Iboga, ibogaine.
Yeah.
Thank you for
Yeah.
clarifying that.
Yeah. Well, that's what happens when you investigate things 5 seconds before the.
We got you, Charles. I've done
You got my back.
that side of the research I've got down. So.
All righty. So yeah. So anybody else have any thoughts about the DEA? I mean, I know Brad thinks they're inevitable, and I think they're inevitable. I just wonder how much role they're going to have in it, and how much they really reasonably ever could have.
I can say something. I would love to hear, Brad. Of course, I'm always happy to hear your opinion about the DEA stuff, especially as this has evolved in the last couple of months, because I haven't talked to any of y'all since like the end of last year. But for what it's worth, so MAPS has been working with some people who are retired DEA for some time, mostly focusing on our FDA related work, so not at all on this topic. But the last time we jumped on the phone with them, earlier this year, I asked, because I was curious, even though it's like, again, a totally different topic, I was curious about like what this particular person's opinion was about this issue. And I got a version of what you said, plus a little bit more. So yes, to kicking it up, like basically people don't want to be the ones to make the decision, but there seems to be a general sense of, I guess you could call it like low morale within DEA around this particular issue, because there seems to be an awareness that the issue is bigger than the systems that DEA currently has built in. And this particular advisor was personally on the side of and seemed to be describing a push within DEA itself to find a solution that basically didn't require DEA to be the primary point, the primary decision maker here. But like you, and it sounds like Brad, like because we're talking about a substance that's currently controlled, I don't, within the current paradigm, see how we could get around that unless it was fully taken off of the Controlled Substances Act, or for some reason the use itself was somehow seen as separate from being a public health safety issue, which I just don't see. Like, with obviously we all understand how it isn't, but I think using the logic that the DEA would be using, I feel like it'd be challenging to get them out. But which is why, like, I really appreciated the letter you wrote, and I'm wondering if asking them to come up with another system is actually a solution, mostly because in our MAPS' experience with the DEA, and again, really wanting to hear from other people who have more experience with them, they seem to not even follow their own guidance a lot of the time. Like, they put out guidance and then don't follow their own guidance frequently. So I personally have a lot of, I feel like I don't have very much trust in the DEA's ability to do it from an administrative perspective, or a willingness to do it, which makes me think that this is just another one of those quagmires. But part of the reason I want to keep engaging with discussion is because I want to learn from people who have more creative ideas, because I feel like that there must be alternatives going to the later questions that you're asking in this thread. So I'll just start there.
Yeah. You know, Brad, you had mentioned in your article in basically inviting a rulemaking proceeding. You share some of your thoughts about that?
Yeah, so first, Charles, thanks for inviting to this.
Thank you for coming.
For those of you who don't know me, I'm attorney Brad Bartlett. This is now I'm part of the Chacruna Council for the Protection of Sacred Plants. I've done a good bit of cannabis business law for a long time, and have moved into assisting with all sorts of issues surrounding psychedelics, including working with various churches that are working with ayahuasca as a sacrament. I did write an article for Chacruna on this very topic, addressing the DEA's guidance document, and suggesting that at the time the guidance document was unenforceable and non-binding. I think that has now proven out in spades with a couple of executive orders that were issued last year by the Trump administration. And I think it's now crystal clear that that guidance does not have force and effect. It is not binding as a matter of law. That said, I don't think the DEA is at all powerless to do anything, vis-a-vis churches' use of ayahuasca as a sacrament. I really want to focus in on ayahuasca here, to the exclusion right now of other substances, and only because There is a 2006 Supreme Court case, the UDV v. Gonzalez case, that took this matter up to the Supreme Court, where the court took a look at whether the agency had a compelling state interest and was utilizing the least restrictive means by implementing a prohibition on DMT as applied to UDV, which was a small, for those who don't know, a small Christian sect that was using ayahuasca sacramentally. The upshot of that court case was a pretty comprehensive decision from the court upholding UDV's ability to keep a preliminary injunction in place to import what the court called ayahuasca. And from there, UDV managed a couple of years later to come to a pretty comprehensive settlement with the agency on all of those matters. I don't think that settlement agreement was at all perfect, but it was at least the start. And then what we saw a couple of years later was Santo Daime litigating similar issues in district court in Oregon. And the upshot of that case was a 2008 court order, and a blanket order at that, basically prohibiting the DEA from interfering with that organization's ability to use ayahuasca, and it included all manner of importation, transportation, distribution, use, and it was a much simpler order. In my mind right now, that particular order constitutes the least restrictive means that are out there for dealing with ayahuasca in a religious exercise context. But that doesn't mean that practitioners who are using ayahuasca in churches who are using ayahuasca don't have to go through a threshold showing or make a prima facie case either to the agency or to a U.S. federal district court to basically prove up that their religious exercise is being substantially burdened by the continuation of DEA prohibitions on DMT. I do think groups have to, if they want to, if they feel that there is a substantial burden, due to the prohibition out there, take some affirmative steps which are allowed for under the law to resolve these issues. The Religious Freedom Restoration Act itself, allows practitioners to step into court and federal district court if you want to. There are also regulations, DEA regulations, that do allow for a quote unquote petitioning process for exemption to the requirements of the Controlled Substances Act, but it's certainly not a mandatory requirement. If you do proceed to federal district court, you do need to be prepared for an evidentiary hearing and answering that question in the first instance, whether or not your entity's religious exercise is substantially burdened by DEA prohibitions. This is a mixed question of law and fact. We have seen the agency, at least in the UDV case, concede issues regarding substantial burden in religious exercise. It's not clear that they would do that in every case, but I think it depends on your threshold showing in the first instance. And I do think you have to answer these questions around sincerity. I do believe it's a different calculus if you're not in a criminal proceeding, right? If you're approaching the agency and asking for some type of exemption, and you're doing so in good faith, and but you do have to evidence, I believe, that your motivations are in fact sincere, not motivated by fraud, they're not motivated by commercial use, they're not motivated by secular self-interest. So you do have to check some of those boxes. I also believe that you do have to at least prove up very minimally that what you're engaged in is in fact religious exercise and not recreational use, which I think in ayahuasca, there should be a presumption that what is happening here is in fact religious use. I think the overwhelming majority, in the literature points to this as well, the overwhelming majority is for religious exercise when dealing with ayahuasca. But
can I ask a quick,
as a threshold matter, I think you have to go through all these showings. So.
A quick question about that last point that you made around the presumption of religious use. So ayahuasca is such an interesting case because it's one of the only, if not, yeah, I would say one of the only substances that's traveled with the ceremony, if you will, where it's really not like, and you can look throughout, there's really not utilized outside of that context in the overwhelming majority of cases. I'm curious about your thoughts on like how, because as of now, due to the situation we're discussing, most of that is underground, would like would the fact that most of the literature shows that, but doesn't necessarily show that there isn't recreational use be sufficient to make that point? Or because I imagine like if I'm thinking about like the hysterical end of the DEA, thinking of like what's a public threat, what's the risk to public safety, I feel like it'd be easy to say, well, it's controlled, we know that it's a psychedelic, they may cause these things, like how do we know that it's being used primarily like in that religious context? Like I feel like there's overwhelming anecdotal and anthropological evidence on that, but I'm curious how you would maybe disprove the possibility of it being diverted, if you will, to recreational versus non-religious use, given that it's all in an underground kind of context, at least within the US right now.
Sure, I think that's an excellent question too. So look, each one of these is, unfortunately, the way RFRA is set up, the Religious Freedom Restoration Act, is you have to take each church on a case-by-case basis, right? Unless you are going to potentially use this, forthcoming DEA rulemaking to advance the conversation in a broader context, right? Which might be a good idea, and I have some thoughts on that. But what the Religious Freedom Restoration Act contemplates is that each individual church has to make its own showing, right? Its own demonstration. And as a threshold matter, the prima facie case is to prove up a substantial burden to religious exercise, right? That should be, even under, and I think maybe most people on this Zoom meeting are lawyers, and I think a lot of us might be familiar with the 10th Circuit Myers test, right? Which is, the court was trying to struggle with what in fact constituted religion in a criminal prosecution for marijuana, where a RFRA defense was asserted, and there were fairly bogus claims, that a couple was trying to use to basically cover up the fact that they were major traffickers in marijuana.
Is that Christie? You talking Christie?
This was the Myers, the U.S. case.
Okay, Myers.
Yeah. And look, since Myers, you've had a change in the definition of exercise of religion in 2000. So now it's much broader than Myers. Now it constitutes any exercise of religion. And even in Myers, the 10th Circuit said, that showing is low. That was the court's term, right? So it's a very low threshold to demonstrate exercise of religion. And now I think because of the amendments to RFRA, it's even lower. It's any exercise of religion, whether or not compelled or central to a system of religious belief. And of course, I think Charles referred to this idea of sincerity of religious belief. There's been a lot of discussion in court cases about that. Most recently in the Hobby Lobby decision, the Supreme Court's decision, which basically extended the privileges of RFRA to a for-profit corporation, which was fairly controversial and kind of went through some extended machinations to have that happen. But I think you still have to make that prima facie showing that you are engaged in a sincere exercise of religious belief. And what that's based on is motivation, right? Are you motivated by fraud? Are you motivated by commercial interest? Are you motivated by self-interest? All those things come into play. And, if you were going to do what RFRA instructs you to do, which is to file in federal district court as a threshold matter, you have to be prepared to prove up all of those things. Now, is there an easy way to get at this? Is there an administrative way to get at this? Possibly, right? As I mentioned at the outset, the Drug Enforcement Administration does have these administrative regulations in place. They're not required. You don't have to go through it. You certainly don't have to comply with the DEA's RFRA guidance. It is non-binding. It's not legally enforceable. But that said, I think the DEA definitely has something to say about all of this, right? And what's going to be really important, I think, going forward for all of the groups is what is going to be the approach. Is there some benefit to moving some of these cases along independently, or is there some benefit in moving with a group approach? For my own part, what I would recommend folks do is really kind of hone in on the obligation for the agency to go through a formal rulemaking at this point, because I think that's what they're obligated to do under President Trump's executive orders, and really move that ball down the field with the best available science and the best available information. And, there are some studies out there that I think point to the fact that the predominant use of ayahuasca right now is ceremonial and religious, and really kind of stand on all of this for a more efficacious way for garnering an exemption to generalized prohibitions on DMT, and what that's going to look like going forward. But I think it's important to really be mindful as you approach these things, right? And try to get it right, and have the folks who are prepared to put the best foot forward kind of blaze a trail for the rest of the groups that are interested in working with this. And I'm not here to tell you all what that looks like. I think that's up for the community to decide, and everybody can have a role, but that would just be my 2 cents in all this.
Hey, Charles, can you hear me?
I sure can.
Hey, Charles, Sean McAllister. Hey, Izzy. Hey, Brad. Hey, everybody. This is the Sean McAllister, attorney, blah, blah, blah. You guys know me. But look, I think the question is this thing, what do we do? And my assessment of this whole thing is we do nothing. That to make a petition is a nightmare, to sue, and I believe Brad would achieve his goal and have a court say the guidance is unenforceable. And where does that leave us? That leaves us in a position to be ready to make an argument in any administrative or criminal context that we have a religious right. But I mean, basically, I think that the policy reform movement needs some more traction over the next few years, and we need to start decriminalizing these substances at the city and state level and build enough momentum and grassroots momentum for change that then we could go seek rulemaking. Because I agree, ultimately DEA or somebody needs to do rulemaking around what are the guidelines here, what are the standards. But anytime in the near future, if they go through rulemaking, just like they did when people petitioned to reschedule cannabis, they ignored the science. They came up with false justifications to keep justifying illegality of cannabis. And until we get a large movement and change at the state level, like we're getting now with CBD, and the FDA is trying to regulate CBD, and when we get to that level, I would be comfortable with the rulemaking. But in the short term, if we force the rulemaking, I think it's a bad idea. It's going to create a bad system. We're going to be fighting that. So my advice to churches is to prepare yourself if anybody shows up, and have your justifications ready. But I don't see anybody in a position to take on a multi-million-dollar fight with the DEA, and the outcome, even if you achieve the revocation of the guidance, isn't helpful, and triggering rulemaking won't be helpful. So sometimes, you don't just do something, you stand there, instead of don't just stand there, do something. So to me, this is the time to build the movement and not be suing the DEA or seeking rulemaking.
Although, hi, Sean and everyone, this is Rob. Related to that point, it appears that SoulQuest, maybe as early as this month, is going to be going into court to sue the DEA to answer their petition. So that may create some rulemaking, or there'll be some consequences to that, conceivably. We're not sure what yet, but that's another something else.
That's true. We can't stop other people from doing that, but all they're doing is forcing the DEA to make a decision. They're not seeking to undo. Well, they'll probably be arguing the guidance is unenforceable. They may get a ruling around that, but they're not triggering rulemaking by itself. Only the agency, or Brad may know, there's probably a way to petition the agency to seek a rulemaking process, but I don't think they're doing that as part of their law.
It's more about their specific exemption, yeah. But there'll be some information coming out of that, yeah.
Well,
I want to say something really quick. My name is Sarai. I also go by Aya, and so something like I'm hearing a theme of ayahuasca, and I think that's incredible. There's amazing people in the room that I wouldn't even know about ayahuasca if it wasn't for them. So yay, thank you so much. And so I'm like, I kind of wanted to speak to like Soul Quest. You brought that up, Robert, which the way that they're structured and the way that they present themselves online is really smart. And if the lawyers in the room could speak up to that, that would be awesome, because they list their church doctrine, what they're all about. They list everything publicly. And I found this like really impressive. I was like, this is awesome. Look at them being so communicative and open about what's happening. And I thought it was really interesting that they even had someone die within their church, and somehow they're still open, they're serving medicine. Like, to me, this was really, really interesting. And so legally, in terms of getting in trouble, because a lot of people are doing this medicine, they're serving this medicine, quote unquote, underground, is Ismail kind of mentioned earlier. And so I guess my question is, it's like, we can take examples that are already happening, and how can we structure ourselves like within a community legally to protect ourselves to the best of our ability? Because I think a lot of people who are involved in this work, it's like, we're not going anywhere. We obviously believe in this incredible medicine and this incredible culture and, what it can do for the world. To me, what I'm most interested in is like, how can I just make sure I'm doing it safely, and how can I serve it to my community in a way that, for the most part, we're protected. If DEA decided to come after somebody, which I just find that interesting that, we have constructs that are publicly talked about in Tucson and then constructs in Florida, and I'm sure everyone's looked at Kentucky ayahuasca. And so it's like, but they're not shut down. And I find this really interesting. I don't know if anyone else finds it really interesting. But so from a legal standpoint, because I don't know anything about this, I just know that I'm a trauma therapist and I want to help people. But from a legal standpoint, how, what do we need to do harm reduction wise legally to go forward and kind of continue a movement?
I'm going to follow up on something that Brad said, because I would have said it, it's actually something Sean said in response to something Brad said. And Sean said what stuck in mind as go local. And when you talk about the reality, I mean, I was my law enforcement experience is limited to, I was a prosecutor in Southern Oregon for a little over a year. I really caught into throwing people in jail, but you do from that position, you find out how problems get presented, who gets charged, who doesn't get charged, and for the same thing.
Right.
Like, okay, so who is, you're talking a little Southern Oregon town, Medford, Ashland, Grants Pass. I tell you, I got a phone call one night. Somebody said, "Is this Charles Carrion?" I said, "Yeah." He says, "Well, your daughter is just being put in the police car right now." And so I said, "What'd she do?" She said, "Cold cock some chick at Ground Zero." I'm like, "Okay." So I drive down to the jail to go pick her up, and she's not there. So I go over to her house. She says, "Oh yeah, they drove me home." Well, that's, privilege of being a daughter of member of the local bar, former prosecutor. It is also the case that ayahuasca churches happen in a local community, they happen in a state, they happen in a municipality, and they have their community of people that relate with. If they have a strategy for how to build those relationships positively, and something I'll remind everyone about that we forget is that it was important to Judge Panner in the Dimey case that the Dimey had received approval for the non-drug use of ayahuasca from the Oregon Department of Pharmacy. They still have that approval. I don't know what we have done, who else has done this, but obviously it's something that any church should think about. Shall I just go directly to my state Department of Pharmacy and try and follow that pattern that was set there and say, we want to have approval for use of it as a non-drug use? And I don't want to monopolize, but I do want to respond to what Sarai said, which is a question of how do we feel reasonably safe to do our practice? And I kind of inveigh a little bit against the idea that we're okay if we just don't get in trouble. I just think that we should have a civil rights orientation that, just like Martin Luther King, who I was just watching a video of him the other night, saying, we just deserve to ride the buses like everybody else, same part of the bus, et cetera, is very important for us to have the courage of our convictions and say, we know our religion is as legitimate as anyone else's. This is what James Madison intended to protect. This is what the First Amendment protects. We are, and we don't need to practice in catacombs anymore. So I think we should always keep that uppermost in mind. To get to that point, we have to have brave people who will in fact say, okay, as long as I can practice and I can share and I am free, I will persist. We obviously need those people, but you're never going to have the reach or, I suggest, the experience that you will have when you can practice in the broad light of day in front of God and everyone.
Hallelujah.
So
may I chime in?
Yes,
Charles, Martha. I'm Martha Hartney. I'm an attorney out of Colorado. I've been working with Brad for, it's been close to a year now, on a particular church's DEA petition. And I just wanted to chime in on a lot of the conversation here and give you a sense of what my sense of the zeitgeist is. I appreciate Sean as the, let sleeping dogs lie, don't stir the pot approach. And that is one definitely valid way to go. With my personal experience and exposure with ayahuasca, I'm no longer willing to do that. I've really been given an assignment to step in and help move this ball because people need it. This medicine is, of all the different types of medicines, it's needed in this world. And as a lawyer, I can't speak freely about my experience and about how this medicine helps, where the potential risks are. And so my personal mission is to move this needle in my own profession. My sense is that this is the right time. We have the right administration under which to do this, a conservative administration where religious freedoms is just the clarion call of the entire administration. So we need to ride that same wave for the religious freedom aspect. And in my mind, I see there's the three ways that we're going about this. One is the religious freedom route, one is the medical and research route, and the third is the decriminalization route. All of them are necessary. And we should all be kind of picking our route and just following that. And I do think that IA is going to be the first to be normalized in our culture because it's not used as a party recreational drug. So that'll kind of lead the way. So for all the other churches that are really working with other medicines, say psilocybin and marijuana, those are going to come after we get ayahuasca, normalized in the public mindset. Oh, this is a kind of a normal thing to do. So that's why I'm putting, my foot on the gas in that arena, the religious exemption of ayahuasca. So I'm not going to back off, even though, we don't know what the DEA is going to do. We don't know what their posture is. But if we handle it carefully and we help to actually set some of those standards that they are looking for, best practices, ethics, how ceremonies are conducted, how we screen people, how we prevent harm, all of those things, we can do that from the religious route and start to set the bar. And that will actually help us on the inside self-regulate, which is what they're going to be looking for. It's a lot of self-regulation. In Colorado, I don't know how, I know there's 1, 2, 3 people here from Colorado. There is a groundswell of practitioners who are going to gather to start some form of an ethical review board, some best practices review board here, made up of professionals and doctors and psychiatrists, psychologists, lawyers, therapists who are going to come together because we've had a couple of poor practitioners here creating harm to other people. So I think the DA is going to start to look to the inner world, like what are you doing to prevent harm? And we need to have a good answer for that. So that's where I'm at. I just wanted to chime in and introduce myself. And
Thank you.
by the way, it would be really awesome to get a list of who's who and who's doing what in this world, because I only know a few people.
I would just say that the other thing about organizing is that NAAVC is basically trying to create a big tent, which is to be an advocacy organization, to be a clearinghouse for best practices, and to make it possible for, I think, to cross over through the formalities of legitimizing religion. You're in Colorado, Martha, and I just discovered the fascinating thing, which is that Colorado passed the, what is it called? The Uniform Unincorporated Nonprofit Associations Act, along with another states. I had never heard of this, but this actually means that without a filing fee or without going to a state office, you can actually create a nonprofit organization, which under Colorado law is legally recognized, can go get a bank account, EIN number, et cetera, and you just write a constitution, it's called. I found that fascinating, as a kind of a low-cost vehicle, because incorporation isn't usually cheap. And I think that the basic business organization methods and what I have learned from representing AYA for the years that I've done it, which is that it's a lot about you saying, how do you make yourself safe? And I'm addressing you, Sarai. How do you make yourself safe? Well, a little trick that we lawyers came up with, I'm afraid, which is that we say what we are, we self-define, and we create a form that when we fill it all in, then we represent that as the thing itself. When Brad was talking about the Myers test for religion, I always hated the Myers test. It's, basically if you're an Anglican, you've got a religion, If we look at how you define yourself, if you wanted to fit that test, you could fit that test because we know what the test is. So a lot of it is having lawyers digest this information, say, what does it mean to adopt the appearance and the form of a religious organization? What does it mean for me to say that my practitioners are congregants, devotees, practitioners, etc.? What makes that legitimate? What kind of obligations do I have as a pastor? When someone, for example, coughs up their whole life story in the middle of the ceremony, what do I do with that? Do I have confidentiality obligations? Yes, you do. You have the priest penitent privilege, I would say, very likely. There's a big issue there. Do other people in the ceremony know that? Or do they perhaps gossip about each other a little bit? Maybe that shouldn't be the case. Ethics, sexual approaches, Me Too, all these things, you know what? We can package them all up and give it to you on a thumb drive. If what's on that thumb drive mirrors who you are, then go ahead, put it on. If it doesn't, mend it, change it from the heart of who you are, what your practice is. You can comprehend that form just as you comprehend that, you know, the way we work is that we have a torso, we got 4 appendages and a head popping off of that, and then we got 5 fingers coming off of each appendage, 5 toes off the bottom ones. You know, oh, and then there's some business down the middle too. You know, that's our form. And we can explain the form of a religion so that if anyone says, knock, knock, you got a religion going on here? Oh, yes, absolutely. Come to the shrine room. We'll start there.
If I could just make 3 very brief points. One is, given the diversity in our community, probably all these different paths we're talking about are going to be followed, which is, of course, the standing still, the looking for an exemption or going to court. So that's why it's really essential that we all communicate with each other and to everyone else in the community to try to coordinate all those paths as best we can. 2, I put a thing in the chat section of something I wrote about legal harm reduction that might be useful.
Yes,
And,
you, Robert, and Charles.
Sure. And 3, just about the people approaching pharmacy boards. It's actually controversial about whether that pharmacy board actually made a ruling. As far as I read it, they just offered an opinion in a letter that had no real standing, because in fact, the Oregon Pharmacy Board doesn't regulate religions and doesn't make decisions about the Controlled Substance Act like that. That's probably true in other states. The pharmacy boards, as I understand it, when someone does get an exemption on the federal level, do play a role in looking at that on the state level. But I think making the expenditure to go and talk to them in the first place might, unless you have a real connection with one, wouldn't necessarily be fruitful. Thanks.
Okay, well, just responding to that really quick, Rob, I think you're right about that letter. What I recall, indeed, is that you had a very friendly, pharmacy board guy. Basically became an expert later for the DIME, if I remember it correctly. The guy who signed the letter, and he signed the letter, and it was withdrawn actually then when there was some political heat, and then it was reinstated, if I know the whole history correctly. And I think the important thing is what and Sean was mentioning is, you know, getting grassroots. I mean, believe me, the decriminalization of mushrooms in Denver and the wider decriminalization that Ismail just told us about in Oakland, they are just about as surprising to me as the fall of the Berlin Wall. You know, and that is because I haven't heard the digging of the people who were digging all this time, digging these tunnels, you know? And so I think that as we, you know, what I'm seeing as an attorney is I am seeing a lot of people, enough people to keep me excited, like Sarai, people expressing themselves like Martha, other people who are practitioners having a very strong sense that this is a virtuous course of action that they want to follow on. And it's the sort of thing that will call forth more than ordinary profit-oriented efforts. So I think that organizing those efforts by, as Rob was saying, sharing our ideas. I mean, I'm anxious to, please feel free to have the ayahuasca healings or Soul Quest attorneys contact me. I would love to speak to them. Oh, and Scott, yes, brilliant, Scott. We've never gotten off of our first question. Does anybody want to move on to the second one?
Okay. This is Samantha Sweetwater. I'm here from California. I just wanted to pipe in one with gratitude for everything that's been said and a couple of finesse points. I run a church that I've not yet legally declared. I've been in the waiting game while I build a community of practitioners who are practicing under religious freedom, like we practice under a common law statement that we are a church. somewhere where I could really use guidance is like on sequencing, like as a church leader, who I do not come, I come from multiple lineages. I'm not Native American, and I'm also in multiple circles working on what is best practice around moving forward together to declare churches in a sequenced way that we could stand in court, but first and foremost where we found the churches. So I could use help with sequencing that. The other piece of activism that I'm involved in is DCRIM, and I'm on one of the advisory boards with DCRIM Nature, which is now actually in 200 cities in 6 countries, as I understand. And if anyone, it's worth looking at the language on the DCRIM Nature site, because if you go into not the language of the main document, which is an exquisite declaration of the veracity of the use of these substances as a community declaration, and very worth looking at as language that is both sacred and bridges to secular law enforcement. But also in the fine print, it includes all molecules, including plants, fungi, and other substances, which includes 5-MeO-DMT. So that's just worth naming. It's not limited to any particular plants. The language is very specific, and they detailed it with law enforcement.
Happy to talk to you.
Thank you so much.
Yeah, I think that you're at the stage where you really need to have some confidential conversations with an attorney.
Agreed. Agreed.
So you're at a very important stage, and the things that you're saying are loaded with significance. We're all we're all biting our tongue. So yeah, NAAVC is here, and you can contact me, and any other attorney.
Thank you.
Volunteer a little chat time. Just go right ahead.
Thank you. And there's a big ripple in that conversation, so thank you.
All right. I'm going to move us back to the questions. Try and move us along here. Thank you very much we really beat the heck out of the first one very nicely. Okay. 2 are the regimes that the UDV and the DIME operate. Let's see. How did I put that?
Charles, I apologize. I have to jump off, but Sean McAllister with Chacruna, I would encourage the last woman to look at the Chacruna website. Tons of stuff out there on sequencing, and talk to some of the great lawyers in the movement. And thank you all for your passion and your work. I'm totally on board with what everybody has said, and thank you for your efforts.
Thank you, Sean. Thank you very much. And yeah, have a great one.
Off to Joseph Ray, I'm also with Chacruna, and I love the diversity of voices we have here, and look forward to coming back on to further conversations here. So thank you.
Thank you very much, Joseph. I really look forward to speaking with you. Take care. All right. Do other folks have some time to continue with these topics, or?
I have about another 20 minutes, Charles.
Great. Okay. Let's just take a quick look at them then. Are the regimes that the UDV and the DIME operate under required or suitable for other visionary churches? Let's just take all 3 of them and then open the floor. Why should an elusive regime like the one that governs peyote distribution network for NAC not be applied to ayahuasca churches? And what about smaller visionary churches that can't afford legal costs of participating in a regulatory scheme? That just takes all of these issues really work together, and I think the last one is really important. But Brad, what do you think of? I mean, you talk about rulemaking. I mean, would you venture a few ideas on, if you were king of the DEA, what you would do to make a just and appropriate system?
Well, and thanks, Charles. So what I would suggest is that this, if you're looking for a looser regulatory regime, this weighs in favor of greater advocacy around these issues in some way, shape, or form. And, I think there are actually many paths forward and a lot of work that could be done. I mean, the idea of working or pressing the agency for more comprehensive rulemaking, and maybe a rulemaking that addresses psychedelic substances generally, but also could hone in on ayahuasca in particular, because there's already been a lot of groundwork that's been laid. That's one idea. You know, the idea that Martha advanced of, you know, some groups just really wanted to press forward, but perhaps using a new approach and a more enlightened approach, and takes into consideration the well-developed case law and changes in the law that are already out there that weren't contemplated back in 2006 when UDV litigated its case before the Supreme Court. Things have changed, right? And I think even the conversation around ayahuasca and the well-developed literature out there changes the nature of that conversation. So maybe advancing some real test cases that are going to take it to the next level for those who are ready to do that, right? And putting the best factual case forward combined with your best legal case, and really pressing the envelope and seeing what shakes out, and maybe trying to get a broader decision around that. That's one avenue. And, you know, with regard to that, you have some options. You know, you can go before the agency and give that a run. There is a petitioning process that is allowed for it. It's not mandatory. You could even make it conditional if you wanted to, or you could just file in federal district court. But I do think it's really important, Charles, you know, and I think you're right to harp on, you know, is the government suited to be making these determinations around what constitutes a religion, what constitutes sincerity of religious exercise. But there is a framework out there for this. And I think the important thing is that the government does have something to say, but how much can it say, right? If you've just met that threshold. And, you know, and that's why I think I started with, you know, these issues with religious exercise that the 10th Circuit was wrestling with, that now I think have been changed pretty dramatically by a new definition of exercise of religion under RFRA. This whole sincerity question, which, you know, came up before the Supreme Court in the Hobby Lobby case. You know, you at least had one Supreme Court justice opine in her dissent that, you know, she felt like that was no longer an appropriate question, that the government shouldn't be in the business of questioning sincerity. But I think what we can say right now at this juncture with regard to sincerity is that you have to look to the motivation. And the time to look to motivation probably shouldn't be when you're in the middle of a criminal proceeding, right? And I think that's really a strong rationale for getting out front on some of these issues, because you're going to be behind the 8 ball if I'm, you know, me or Joe or Sean, are like your criminal defense attorney trying to defend you from all this and try to use RFRA as an affirmative defense. I think it's a much different case and a much different equation if you were putting this out and standing on the fact that, hey, I'm going public with this. I'm proving by virtue of the fact that I've submitted this to you, agency, that should demonstrate in and of itself that I'm not being motivated here by fraud or criminal activity or commercial activities, secular interests, what have you. But really pressing the envelope on those issues and getting some concrete decisions around these things and some greater clarity, I think is really important, and doing it strategically. I think your letter was a good first step, Charles. I'd be really surprised to see the DEA respond. I do think, and you and I had this conversation when you sent the letter, that you know, there is an up level, and you know, Sean spoke to this very, very eloquently and kind of warned of the dangers of pressing the agency for rulemaking. But I do think there are some advantages in pressing the agency for greater clarity around these decisions. And you know what? There is a Religious Freedom Restoration Act, and it is very clear, right, that the agency has to make an accommodation for religious exercise. And I don't think that accommodation should be steeped in the agency's regulations for the manufacture and distribution of drugs, right? Yeah. I think it needs to be a much more generalized carve out consistent with the district court's decision in Oregon in the Santa Daime case, right? And as I said with my first go around here, I believe that now is the least restrictive means for dealing with the ceremonial use of ayahuasca in a religious setting. And the question now becomes, how do you get there, and how do you build in, some type of meaningful administrative framework that opens that door even further than UDV opened it.
Well,
And I think that's where we are right now.
Brad, to that point, when the DEA is given exemptions to other diocese churches now, they do follow that scheme, and it really isn't that onerous. All they have to do is show that they have their medicine locked in a secure space, and they're supposed to have record-keeping inventory and how much they use the ceremony, but the DEA doesn't monitor that except maybe once a year, and they call before they come, so they're really and the relations that the DIME and, as far as I know, the UDV2 have with the DEA is actually friendly, and these people that are coming are not the agents that knock down doors with guns. These are the people that regulate pharmacy and drug manufacturing, so it's kind of a more interesting part of the day when they have to talk to them. So.
Yeah. And you and I have talked about this, Rob, and with Brian too. And I think an ounce of self-regulation by all the groups is going to go a long way. And I think that's why your article is really important. And, really getting out front with, the principles for engagement with ceremonial use, ethical considerations, even if you're operating as a church, what does it mean to meaningfully pastor, or whatever you want to call it, be an ayahuasquero in the ceremonial settings? What are the ethical responsibilities for someone who is administering ayahuasca in a sacramental setting, and having those conversations and really getting out front? Could there be a certification process? Not beyond the realm of possibility, right? You see a lot of organizations that self-regulate. And so it's not beyond the realm of possibility that, entities decide, hey, we want to self-regulate ourselves so we can become legitimate in this regard, right? Maybe people go through some types of training, right, with all of this. And, you become certified in being able to administer this, and it's all a self-certification process. So just things to think about as you get into this. And I think the calculus for ayahuasca is going to be a lot different than any other controlled substance, because it's a lot farther along. And I think it checks the box with ceremonial use in a way that other naturally occurring psychedelic substances don't. But for peyote, which is, I think, in a class in and of itself, by virtue of the Native American Church and the historic and traditional relationship with Indian communities working with it. So
it's interesting that you say that about ayahuasca, especially because going back to that earlier point, like, because it's traveled with the ceremony, there is, and I think part of what allowed the Supreme Court to recognize the UDV is also the existence of the church in another place that had originated in another place that had been proselytized. And I think similarly, the fact that if you were to do a religious ceremony with something that wasn't ayahuasca and wasn't peyote, barring a very small number of examples that are mostly fully indigenous or traditional, all of that would be syncretic, but it would be like first approach syncretic. It'd be the first time where the current religious paradigm in the United States saw something like mushrooms or LSD, for example, actually met with a religious structure. It'd have to be authentic or perceived as authentic and fully focused from the very beginning, which makes it so much more difficult and such a lift and puts in a different category as something that at least does have all of this other precedent and all of these other breadcrumbs.
Hi, my name's Renee Miranda. As I wanted to introduce myself and say a little bit about who I am, because I just know a couple of people here and I don't know the attorneys. I am in Tucson, and I facilitate ceremonial ayahuasca ceremonies. I'm a very, very small operation, and I haven't done anything legally. I'm not incorporated as a church. And so the last question was of great interest to me, about what about small entities that I've been doing this work, and I know that I'm ethical, and I know I'm following proper guidelines, and I have a medical background. I'm an MD, but I haven't practiced for a while actively in the Western medicine system. And I know that this is that this medicine, that ayahuasca, is so powerful and so beneficial to so many people. And I feel super strongly about it because that's why I do the work. So I'm wanting to learn. I'm wanting to get more information and see what moving forward, because I'm having an increasing interest from people who are interested in sitting with me, like, about the legal aspects. And yeah, and it's coming up more and more, which is understandable and important. So I just wanted to let you know who I am, that I'm interested, and I'd like to continue to learn more and create the most protected environment that I can, from a legal perspective. I know that I do that in all the other ways.
I'll just invite you to join NAAVC, and we'll certainly share the camaraderie and the developing approach that we're developing. And we are thinking about small practitioners, and so I'll just jump to that last question, because I think Brad really addressed the other two very nicely, and thank you for your contribution there, Rob, as well, and Ali. But it seems to me that when I think about the NAC system, and I just sort of have an image that there are the four pickers, there are the four licensed DEA licensed pickers in South Texas, and at some point, NAC guys drive up and gals drive up in pickups, and they pick up gunny sacks of peyote and probably weigh it, or maybe they've counted the buttons. And that's the accounting that's done, and the pickups head off to the horizon, and that's the last regulatory act, And after that, the practitioners have control and are trusted, and of course they're worthy of that trust, as the courts have again and again noted. I ask myself, since most of the ayahuasca comes from foreign shores, or at minimum from Hawaii, and has to effectively be imported, can we not seek to establish an organization that will be an importer, and it will have an importation and manufacturing and distribution license, and that churches can sign up with, just as NAC churches undoubtedly do, so that they can obtain their sacrament, and that the regulatory relationship between the importer and the DEA could be sufficiently rigorous that it would satisfy them, that the downstream distribution of the churches would be sufficiently liberal, that it wouldn't impose too many regulatory hurdles for people and costs. So that's what I'm thinking. To me, that's the big place where all little critters can get together and be able to get themselves a chunk that is adequate to their needs. I don't know if you had kids, but when I was a kid, when I was raising kids, we had this one little book that the kids really loved that was called Swimmy, about all these fish, and Swimmy was a funny little fish because all the other fish were silver and he was black, and so they avoided him and they didn't want him in the school. But then he found the perfect place. He became the eye, as all the other fishes swam in the shape of a big fish. His little black eye, and they all moved along as one great big fish. And so if we school together, we get more advantages than just not being the first one to get bit, which is your primary advantage in schooling. But also we can queue up with the big guys and get what we need. And you don't, the UDV, great, they had Jeff to help them out. The Daime, they had been around for years, and they literally had 3 archbishops sign their petition. That's something that AYA is not going to be able to bring to the table. Renee Moran is not going to bring to the table. Other small churches around the country are not. So we absolutely have to work together. And I see having centralized importation and simplified downstream distribution as something important. Obviously, staffing and capitalizing something like a centralized importer, the big task for the professionals who know what they're doing, and like I say, have some capital. But I do think that we could, to me, that seems like something that could go off to court and try and get that license, or you get together with Brad and you do a petition through the DEA. And with that, I think we're now, somebody said 20 minutes. Brad, I think we're into overtime for you. So I want to thank everyone for being here, and all of you who spoke, thank you for speaking. All of you didn't, thank you for listening. And let's keep it rolling.